Order, order. We start with questions. Secretary of State for Justice, Mary Rimmer.
Thank you, Mr. Speaker. Number 1.
Mr. Speaker, custody is reserved for those convicted or accused of the most grave offences, and the total number of children in detention has fallen by 82% since 2010. Before a child can be remanded, the court must be satisfied that it is very likely that the defendant will receive a custodial sentence and must have explicitly considered and rejected the option of remanding him or her into local authority care.
Mary Rimmer.
Thank you, Mr. Speaker. 44% of the places in youth custody are taken up by children and young people on remand. Most of these do not go on to receive a custodial sentence. Yet these children held in young offending institutes spend most of their time locked up in their cells and in very high levels of violence. Does the Minister think that is the best place and time where to spend their time during adolescence?
Well, the Honourable Lady makes an important and compassionate point, and it's absolutely right that we should invest in the estate, and I'm pleased that we're investing in a new secure school which will be opening soon. But she makes an important point about the decision to remand. Those decisions are made by independent judges, that's correct. But I hope she will join me in recognising that the reduction in the overall number of children in custody by 82% since 2010 is a positive thing. When I was prosecuting, young people were going inside for being passenger in a vehicle taken without consent. Now they're only inside for the most grave offences.
James Gray.
Mr. Speaker, will the Lord Chancellor take consideration of one recommendation of the Wade report into sentencing for murder, and that the definition of children should be reconsidered? At the moment, if you are 16 or very often 17, you might well be tried when you're 18, but nonetheless your sentencing is as if you were a child. Surely the question should be the crime rather than the age.
Well, I mean, we have altered the sentencing regime such that the courts can take into account what can be potentially quite significant gaps between the sentence regime which applies to a 17-year-old and that which applies to an 18-year-old. So the courts do now have additional discretion to ensure that if somebody is very close to their 18th birthday, that means that they're entitled to treat them as more mature, and that can mean in appropriate cases that the punishment will be more severe.
Minister Janet Daby.
Thank you, Mr. Speaker. Mr. Speaker, when a child is on remand and is placed in youth detention, almost 2/3 of these children do not go on to receive a custodial sentence. And 17% of these children were acquitted, which means they were freed from a criminal charge altogether. It costs between £129,000 to £306,000 per year to keep just one child on remand in youth custody. Does the Minister view this to be the best use of public money, or does he feel this could be managed in a more efficient and effective way in an alternative remand provision?
Well, I'm grateful to the Honourable Lady for her question. So in 2010, the total number of children in custody was over 3,000. The figure now is around about 500 or so. So there's been a very significant reduction. But the decision whether to remand is a matter for the judges. They can only remand in custody if there are substantial grounds for believing, if released on bail, that child will commit further offences whilst on bail or indeed fail to surrender. What we're also doing is investing millions of pounds in, for example, Greater Manchester, to see whether there are other options where children could be remanded into local authority accommodation and not necessarily in custody. But
Tonia Antoniazzi.
Question 2, Mr. Speaker.
Thank you, Mr. Speaker. With your permission, I will answer questions 2 and 8 together. With the Victims and Prisoners Bill, we're putting the Victims Code onto a statutory footing. This includes a right for any victim of crime to be signposted by the police to correct and appropriate support services. We have quadrupled victims funding since we took office in 2010 to over £150 million a year and recruited almost 1,000 ISVAs and ISDAs into the criminal justice system. In addition to this, we provide a range of free phone support lines, including a 24/7 hotline for rape.
Tonia Antoniazzi.
Thank you, Mr. Speaker. Rapists, domestic abusers and stalkers can't be convicted if trials aren't going ahead, and victims are dropping out after being made to wait years for justice. Where is the government's plan, Minister, to tackle the record court backlog which is making these victims wait years for justice?
Well, I thank the Honourable Lady for her question. We are doing a huge amount to drive down the backlog, which was principally a result of the pandemic. We've increased the fees for both solicitors and barristers by 15%. We've kept open more than 20 Nightingale courts, and we are doing everything within our power to drive down waiting times.
Gareth Thomas.
Bearing in mind that Harrow Crown Court is not set to reopen for another year because of Minister's failure to invest in its repairs early enough, what confidence can victims of crime in Harrow have that ministers are actually going to get those that are accused of those crimes to justice much more quickly than is currently happening?
Well, I thank the Honourable Gentleman for his question. The issue with Harrow Crown Court, he will know, is that RAC was discovered in that. We are investing more than £220 million into the court estate because we know how much it matters, not just that the courts are functioning, but that the buildings convey the right sense of dignity so that people respect the process. And Harrow is just one of 350 courts in England and Wales.
So the Select Committee's Robert Neal.
Thank you, Mr Speaker. The Minister is right to recognise the work that's being done in relation to the Victims' Code, and I appreciate the Government taking on board a number of the recommendations of the Justice Select Committee in relation to that bill when we had pre-legislative scrutiny of it. But in terms of delays, the Minister will know that there's a particular issue of delays in rape and serious sexual offence cases, where cases are taken out the list because prosecuting counsel are not available and simply cannot be found. She rightly referred to the increase in fees for solicitors and defence counsel. Would she agree that there's just one piece of the jigsaw that needs to be put in place now, and that is to bring the fees for prosecuting counsel in these cases up to the same level as defence counsel? That would take about £1.5 million. Will she sit down and talk with the Attorney-General about how we can do this swiftly?
Well, I can reassure the Chair of the Select Committee that I spoke to the Chair of the Bar Council about this exact issue last week, but I want to provide him with some reassurance. First of all, we have had correspondence between the Lord Chancellor and the senior presiding judge about any case of rape that is more than 2 years old. That correspondence was a couple of months old, and he said that all cases would be listed by July of this year, so that there will, and that applied to 181 cases in England and Wales. I also want to draw his attention to something I know he will be aware of, that we have increased the fees for Section 28 hearings, which we know take place in an irregular sequence in the court listing, from £670 to over £1,000.
Demandra Jenkins.
Thank you, Mr Speaker. The Telegraph reported on Monday that civil servants are trying to block an amendment to the Criminal Justice Bill that would legislate for the publication of an annual report on crime stats by nationality. Does the Minister support the release of such a report? And what does he think civil servants are worried will find out? Minister, it's time to publish a report and restore trust for the general public.
Well, I thank the Honourable Lady for her question. I'm not aware of this, but I did know that an amendment had been suggested and was not in the scope of the bill. I do think that that is a sensible suggestion. I would simply say this. We do already publish the number of foreign national offenders in prison, but I do understand the force of her question, and I'm happy to meet with her and discuss it further.
Absana Begum.
Thank you, Mr Speaker. More than 60 lawyers, campaigners, politicians and academics have written a letter in support of the Anti-Violence Against Women and Girls campaigner and barrister Dr Charlotte Proudman, who is facing disciplinary action after challenging a judge for having a boys' club attitude in a ruling on a domestic abuse case. Does the Minister agree with me that the racial, gender and class-based bias of the justice system must be addressed, that it's right to speak up against injustice, and will they join me in paying tribute to those who are campaigning for a legal sector which genuinely represents, empowers and is accountable to the wider public?
Well, I count myself as one of the people who campaigns on violence against women, and there are many other honourable and right honourable members across this House who do the same thing. She will understand, I hope, that I'm not going to get involved in the disciplinary matter concerning a particular barrister. I know what it is said has been said, and that will be a matter for the relevant standards committee to decide whether or not she's at fault.
Mike Penny.
Thank you, Mr Speaker. The Minister may be aware that I used to be the Victims Minister, and when I was the Victims Minister, I tried to stand up for victims whose loved ones have been killed by a road traffic incident. It is fundamentally unfair that if someone is charged with death by careless driving compared to death by dangerous driving, careless driving is not appealable by the victim for leniency. Is that something we're still looking at? Because that was there when I was in the ministry.
Well, I thank my honourable friend for his question, and I share his profound concern about death caused by either dangerous or careless driving. He will know that it was the Conservative government that created a criminal offence of death by careless driving. Just to say 2 points. First of all, since the 28th of June 2022, the maximum penalty for the offence of death by dangerous driving has been increased to life. Previously, it was 14 years. On the unduly lenient scheme, we have just agreed to extend that scheme so that the Attorney General and the Solicitor General will have 28 days, for the complainant to put in their appeal, and they will have a further 14 days to contact the court. We hope that will encourage more applications, and of course, we keep the category of offences under careful review.
Shadow Minister Kevin Brun.
Thank you, Mr. Speaker. Victims should have the right to know who this government is letting out of jail early. With today's news that despite ministers' protestations to the contrary from that dispatch box that high-risk offenders have been released early, why should the public have any confidence that this is a government which puts victims first?
I want to provide some reassurance to the Shadow Minister. Under our scheme, no sexual offender, no terrorist offender, nobody who has been convicted of a serious violent crime or been convicted for 4 years or more will be eligible for release. And just to remind him of the slight distinction between our scheme and that was conducted under the last Labour government between 2007 and 2010 is that we have a governor lock, which means that the governor of any prison can prevent an individual prisoner from being released early if they don't think that that's suitable. That was not the case under the last Labour government.
Alan Brown.
Mr. Speaker.
Mr. Speaker, the Employment Tribunal panel composition arrangements are now the responsibility of the Senior President of Tribunals, and I understand that he intends to publish the response to his consultation on proposed reforms shortly. The Senior President has a statutory duty to consult my right honourable friend, the Lord Chancellor, before making these arrangements, and my noble friend, the Parliamentary Under-Secretary of State for Justice, will be meeting with the Senior President, I think tomorrow, to discuss his proposals as part of this duty.
Alan Brown.
Mr. Speaker, the introduction of tribunal fees previously led to a 54% drop in cases going forward, and the scheme was deemed unlawful by the Supreme Court. So it beggars belief the government's looking at reintroducing tribunal fees, giving a green light to bad employers to exploit workers though they will be deterred from going forward. So what does he say to 50 organisations, including the TUC, Citizens Advice, Joseph Rowntree Foundation and Liberty, calling the government to reconsider this reintroduction of tribunal fees?
Member for his question. Many of these issues were actually raised when the statutory instrument was passed through Parliament, and my honourable friend, the member for Finchley and Golders Green, who is the Court's Minister, has written to the Senior President to convey those concerns to him, and I think that in part is why my noble friend, the Under-Secretary of State, will be meeting with the Senior President tomorrow.
Shadow Minister Alice Cunningham.
Thank you very much, Mr. Speaker. The wheels of justice, well, they certainly do turn slowly under this government, and hundreds of thousands of people across the country are paying the price in the Crown Courts, the Civil Courts, the Family Courts and tribunals. At the end of 2023, the Employment Tribunal background stood at more than 460,000 cases. That's cases affecting workers who have been bullied, workers who have been denied pay and workers who have been unfairly dismissed. Does the Minister think that workers like the government should just give up on the justice system, roll over and accept what employers do to them? Or is there a new magic formula to sort this out?
Mr. Speaker, the one thing that the honourable gentleman didn't, of course, mention was the impact of the pandemic on the criminal justice system and indeed on the employment tribunal system. The front bench don't like hearing it, Mr. Speaker, but you cannot ignore the impact of effectively shutting down the system for 2 years. We have massively increased the resources available to this, and we are working through the backlog, but this will take time.
SNP spokesperson Chris Stevens.
Well, thank you, Mr. Speaker. And a similar point, in a cost of living crisis, workers are now expected to pay to take their employer to an employment tribunal in cases of wage theft, unpaid redundancy pay and compensation for unfair dismissal. This is quite frankly outrageous and being levied at a time of intense pressure on family budgets. So, does the government not agree that access to justice must never be contingent on one's ability to pay, and these proposed changes ought to be scrapped to promote greater fairness in the system?
I thank the honourable friend for his question. We have introduced a virtual regional court in order to safeguard access to justice, and we will always make that we always make that available as far as it is possible to do. And as I say, we are working through the backlog at pace.
Alison Thorpe.
Is that an answer?
Number 4, Mr. Speaker.
Thank you, Mr. Speaker. The Honourable Lady asks about the implications for the criminal justice system of the Safety of Rwanda Act 2024. To be clear, this act related to immigration and potentially administrative law. It doesn't substantially impact the criminal law, and accordingly, no specific guidance is required.
For that response, and may I praise the quick response from solicitors and from the community in Glasgow to Rwanda removals, very much in the spirit of the Glasgow Girls, the Glasgow Grannies and Kenmure Street 3 years ago. Can I ask the Minister, is there a deliberate policy to remove people from Scotland to England to prevent them accessing legal aid as they were able to do so in Scotland and would be fully entitled to do so? What guidance has been issued to lawyers in this respect? And lastly, what right do MPs have to intervene in cases of removal? Because I've been told that MPs have been requested to have wet signatures from people who've removed to immigration removal centres in England.
Well, there are several questions in there, but the first question was no, that isn't correct. The point about legal advice is really important. People should get legal advice so that they can make their points. That's why we're investing heavily. When the IMA comes into force, there'll be a 15% uplift. We're investing £1.5 million to re-accredit senior caseworkers, and also we're paying for travel time. We recognise, of course, this is robust legislation. It's necessarily robust. We're also ensuring that people get the legal advice they need.
SNP spokesperson Chris Stevens.
Well, thank you, Mr. Speaker. I listened with great interest to that answer. My honourable friend from Glasgow Central, my honourable friend from Glasgow North East, and a Glasgow South West constituent have been removed from Scotland to England and threatened with deportation. Can I answer this question? Why are MPs being denied access to their constituents? It seems quite outrageous, and does he not think it's unacceptable that lawyers and their elected representatives should not be impeded with arbitrary barriers when accessing their constituents threatened with that deportation?
I am more than happy to discuss with him the point that he's raised, and I'd be happy to do so. Of course, MPs should have access in appropriate circumstances, but the critical point is going to be for individuals to get legal support with no discourtesy to him as a constituency MP. That legal support is important. As I say, when the IMA comes into effect, we will increase funding by 15%, also pay for travel times, and also ensure that there's re-accreditation of senior caseworkers. That's what individuals need, support through legal advice, and that's what we're providing.
Just more.
Number 5, Mr. Speaker.
Thank you very much, Mr. Speaker. I'm grateful to the Honourable Lady for her question and also for her typically measured and sensitive contribution to yesterday's urgent question on this issue. Ensuring that our prisons are safe and secure for both staff and prisoners remains our top priority. HMPPS has been working closely with G4S, the operator of HMP Park, to ensure the welfare of prisoners, and I visited last month to see this work for myself. I am particularly conscious of the importance of this in the light of the 9 deaths in HMP Park since March.
Jessica Morden.
Thanks, Mr. Speaker. And yesterday, as the Minister referred, I had the opportunity to raise the concerns of parents with sons at Park. They're very real concerns, particularly in relation to drug use. When I contacted the prison 2 months ago, they replied saying that in the year to September 23, there had been a shocking 1,600 incidents of self-harm in a prison of 1,800 inmates. Does the Minister accept that parents have been asking for particularly mental health support for years and it's not been happening?
Well, I'm grateful to the Honourable Lady again for her question. The provision of mental health support is absolutely vital. It's obviously something that needs to be done hand in hand in partnership with the local health board in Wales, covering Park. We continue to work closely with the health board, both on that issue that she's raised, but also more broadly on the issues that are underpinning some of the challenges faced in Park.
Vicky Ford.
Aware of the dire and indeed dangerous situation we faced at Chelmsford Prison 3 years ago when the prison was placed in special measures. He may have seen the latest inspection report, which praises the improvements, especially in being a safer and more productive place, and the work they've done to take drugs and contraband out of the prison. I'd like to thank the Justice Secretary personally for the focus he gave this when he was Prisons Minister, as well as congratulating the Governor and staff there. Does he agree with me that these lessons from Chelmsford could help other prisons like Park, and shows that with the right approach, even the worst prison can be turned around?
I'm grateful to my honourable friend for her dexterity in asking her question, but she makes a very important point, both in respect of paying tribute to the work that's been done at Chelmsford Prison, not only by my right honourable friend in working with the team there and all the staff there, but also the close interest she's taken and how much that means, I know, to the staff and the team at her local prison, but quite rightly, the opportunities for learnings from that may well benefit prisons such as Park.
Lily Greenwood.
6, Mr. Speaker.
Thank you very much, Mr. Speaker. Over the 10 years to 2022, proven reoffending rates, cautions and convictions for children and young people have fallen from 40.4% to 32.2%. While in the last year there has been a slight uptick, the fact remains that reoffending by children and young people has fallen significantly under this government.
Lily Greenwood.
Last week I went to see the powerful new play Punch by James Graham. I cannot recommend it highly enough to all honourable and right honourable members. You're very welcome to come to Nottingham Playhouse to see it. It raises important questions about young men and their offending behaviour and shines a light on the potential power of restorative justice. What role does he believe restorative justice can and should play in tackling reoffending, which, as he said, has risen for the first time in a decade amongst both adults and children?
Well, I'm grateful to the honourable lady, not just for her question, but for her recommendation and her kind invitation to the Nottingham Playhouse, which, as she knows, is just up the road from my own constituency in Leicestershire. So she may find I take her up on her kind invitation. To the substantive question she raises in terms of restorative justice, while, of course, decisions on that would be a matter for the judges, and there are relevant considerations to take into account, I do see restorative justice as being one element of a package that can actually help reduce reoffending and help get children and young people who commit crime back on the straight and narrow.
Beth Winter.
Thank you, Mr. Speaker. Question number 7.
Thank you very much, Mr. Speaker. The government takes a zero-tolerance approach to drugs in prison. This is reflected in the policy approach adopted by us, which has seen £100 million worth of investment into measures to tackle the smuggling of contraband, including drugs, into prisons. In the year ending March 2023, there were 19.7% fewer incidents where drugs were found than in the year to March 2019, and so reversing that pre-pandemic trend. While there remains more to do, it's important to note progress has been made.
Thank you, Mr. Speaker. The most recent Inspectorate of Prisons report into HMP Park Prison in 2022 found that almost half of prisoners had easy access to drugs, and our current Welsh Affairs Committee inquiry into prisons has also received evidence regarding drug use, as well as the fact that Park is both understaffed and the staff are inexperienced. So in light of this evidence and the recent death surge in recorded violence in Park Prison, would the Minister welcome a new inspection of Park by the Chief Inspector? And, given the £400 million cost of the contract to G4S to run the prison, has he given consideration to the prison service stepping in to manage it, as it has done with Birmingham Prison?
Thank you, Mr. Speaker. There's a number of points made there. In terms of tackling drugs in Park, we have X-ray body scanners, we have the RappiScan systems, and we also have handheld devices being rolled out. In respect of her two specific questions, any inspection is a matter for the Chief Inspector of Prisons. In terms of the overall performance of Park, I think it's important to remember that while there are challenges that were addressed in the urgent question yesterday, Park is a prison that is rated as performing well, and a contract that is performing well. I think in the 2022 inspection it got 1 measure of good and 3 of reasonably good. There is more to do, and we will continue to work with the prison, but the contract continues to perform well.
Minister Ruth Gabley.
Thank you, Mr. Speaker. The government boast, and have done just now, about their investment in new body scanners to detect drugs on everyone entering a prison each day, yet a damning report in The Times found that the body scanners at HMP Bedford weren't even staffed. So what's the point of spending £100 million on scanners if they're not used?
Well, I'm grateful to the Honourable Lady, and before turning to the substance of her question, may I take the opportunity to wish her a happy birthday today. It's important to remember that this investment is across the estate. I was in HMP Wandsworth yesterday and I was seeing the work that's being done there. The body scanners are used in the context of Bedford. They were used at appropriate times in an appropriate manner.
Mr. Graham.
Number 9, sir.
Mr. Speaker, MOJ reoffending statistics show that those serving a sentence of 6 months or less have a 59% reoffending rate. For offenders punished with suspended sentences or community orders, the reoffending rate is 24%, and the Department's 2019 analysis of a matched cohort of over 30,000 offenders showed lower reoffending rates for those serving sentences in the community when compared to immediate custody of less than 12 months, avoiding tens of thousands of potential crimes.
Graham.
I'm grateful. I agree with the Bishop of Gloucester that very often community payback schemes are far more appropriate, particularly for women prisoners, than short-term custodial sentences. If my honourable friend agrees, does he also agree that we could expand the range of community payback activity, for example, to include helping at good local charities like the Nelson Trust and the Family Haven, and perhaps especially during this summer season of litter picking across the country, keeping Britain tidy?
I thank my honourable friend for what I think is a very sensible question, and I do agree with him. I think community payback offers offenders the opportunity to make visible reparations to their local communities, with millions of hours being delivered each year. And as an example, this March, the Great British Spring Clean, offenders spent thousands of hours clearing litter across the country. And we're trialling a new way to deliver community payback through Rapid Deployment Pilot, which was launched last year. And the community payback teams are working in partnership with local authorities to see incidents cleaned up within 48 hours' notice, and we are now expanding that to all 12 probation regions.
Jim Shannon.
Thank you, Mr. Speaker. Can I thank the Minister very much for that? Restorative justice in Northern Ireland has been one of those very effective methods of ensuring that the victims and the perpetrators at least are able to come together and perhaps maybe try to find a solution. It's also a way of ensuring lesser sentences as well. So has the Minister been able to look at the community restorative justice that we've done in Northern Ireland on the mainland here to ensure that those who offend can have a new life as well? Thank you.
I thank the honourable gentleman for his question. I personally haven't, but I'll be very happy to meet with him to hear more about that. But I gather that Ministry of Justice officials are abreast of that, but I would like to hear it from him personally.
Jeff Smith.
Thank you, Mr. Speaker. Question 10.
With permission, Mr. Speaker, I shall answer questions 10 and 13 together. Thanks to funding by the Prime Minister as Chancellor, we are delivering the largest prison building programme since the Victorian era, with 10,000 additional places on track to be delivered by the end of next year. To secure the pipeline of further prisons, last October I announced an investment of £30 million to acquire land even further in advance to mitigate the risk of planning delay. We are also delivering an additional 460 rapid deployment cells across the estate.
Jeff Smith.
Well, Mr. Speaker, the National Audit Office warned the government over 4 years ago that prisons would run out of space by 2023. Of the promised 20,000 places, it's been revealed that only just over a quarter have been delivered. So as a result, we've got the government spending £50 million renting out police cells, we've got grim conditions in overcrowded prisons, and we've got a chaotic early release scheme. Why have the government proved incapable of averting this crisis?
So, as a result of the record amount of investment in prisons, we brought on HMP Fossway, we've HMP Five Wells, and I would invite him to visit them. These are excellent modern prisons with fantastic rehabilitative conditions and excellent opportunity to keep the public secure and prisoners rehabilitated. We'll also be rolling out HMP Millsike. We have planning permissions also for HMP Gartrey, but we're also rolling out house blocks at Stocken, Rye Hill, Guys Marsh. There'll be further ones at Gartrey. This is a government that believes in building. We're getting on with the job.
Murray Robinson.
Thank you,
Mr Speaker, part of managing prison capacity is ensuring we have enough prison officers. But being a prison officer can be both demanding and dangerous. 70% of prisoners are between the ages of 25 and 49 at the peak of their physical fitness. My prison officer constituent told me that despite this, officer retirement age is 68, meaning staff well into their 60s are dealing with young, often aggressive people. Whilst it's important to retain experienced prison officers and recruit to the service, what consideration has my honourable friend given to reducing retirement age in line with policing?
Grateful to the honourable lady. So prison officers are the absolute backbone of the system, and it's absolutely right we should recruit and retain. I'm pleased to say that in the last year, 2023, we recruited an additional 1,600 officers, and just as importantly, the resignation rate is coming down from 10.5% to 8.5%. That's really positive. On the point she makes about retirement, it's also worth knowing that the employee contribution rate to pensions is one of the most competitive of prison officers in the public sector. That's exactly as it should be. On the specific point of retirement age, I will of course be happy to discuss it with her further.
Mr Speaker.
It is important to flag, of course, at the outset that confidentiality clauses are only ever used in the civil context rather than the criminal. But with that in mind, Mr Speaker, we are bringing forward an amendment to the Victim and Prisoners Bill that will make any non-disclosure agreement void if it purports to restrict the right of an individual to report the same act to the police or to access any kind of medical or therapeutic support, a move that has been welcomed by many, including the Law Society and the Bar Council.
Thank you, Mr Speaker. Thousands of people are silenced due to non-disclosure agreements and gagging clauses in alleged cases of sexual violence, bullying and harassment. The Legal Service Board reported signatories of NDAs suffering devastating impacts due to fear of retribution, and the Pregnant Blood Screw says today an estimated 435,295 mothers have been gagged by an NDA or confidentiality clause. The bill tabled by my honourable member, my friend from Oxford, West and Abington, would end the misuse of NDAs in the workplace. Why is the government so hesitant to support a statutory ban?
Well, as somebody who spent more than a decade practising as an employment lawyer, there is a role for the confidentiality clause in any kind of compromise agreement when both sides resolve their dispute without going to court, without admission of liability and without any finding of liability on either side. But with that in mind, we recognise that used in their most extreme form, particularly in some of the most high-profile sexual harassment claims, victims have told us that they felt they couldn't go to the police, they couldn't access counselling, and we've righted that wrong. But I will stand up for confidentiality clauses. I want to just make one slight correction to her point. They're only really encountered where there is a dispute concerning the Equality Act. That needs to be immediately contextualised. It only applies in employment, in education and in the provision of goods and services. And we've taken the same step in relation to students through the Higher Education Freedom of Speech Act 2023.
Blackman.
Number 12, Mr Speaker.
Speaker, I will answer questions 12 and 17 together. I'm so sorry? Just one question. Reducing reoffending is a core mission of these ministers and this government, and that's why we've prioritised accommodation for prison leavers. It's also why we've invested heavily in employment, with prison employment leads and employment hubs in every resettlement prison. Crucially, the plan is working. In the 2 years to March 2023, the proportion of prison leavers in employment 6 months post-release more than doubled.
Bob Blackman.
Thank you, Mr Speaker, and I thank my right honourable friend for that answer. Clearly providing a safe and secure accommodation for ex-offenders when they leave prison is the first and most important part of getting them on the path to rebuilding their lives. Yep. So what action is my right honourable friend taking to ensure that happens so that people are not tempted to reoffend?
And for that question, no one in this House has done more than him to look after the plight of people who are either homeless or at risk of homelessness. I'm proud to say that the proportion of offenders in homes post-release for their first night is 86%, and that's because we've rolled out community accommodation, a guarantee of 12 weeks accommodation. And when I went to Luton and Dunstable and I spoke to a probation officer who'd been working there for 30 years, he said that that was the single most significant policy rollout in his entire career. It's critical to ensure that prisoners and ex-offenders can be rehabilitated.
Mr Speaker, does the Minister agree with me that reoffending rates would reduce further
if we have a more concentrated attack on the illicit substances that continue to go into prisons, as well as the massive over-prescription drugs that are now used in prisons that many people in prisons tell me are causing problems for people close to release.
Excellent point. Of course he's right about that. But reoffending rate is something worth focusing on. So in 2010, it was around 31%. It's now 25%. And the reason for that is a combination of focusing on accommodation, as we've just discussed, also employment, so people have a stake in society, but also substance abuse. So one of the things that we are looking at with great focus is technology to ensure that people can be treated for their substance addiction by the very clinicians on the inside that they will be treated by on the outside as well. That continuity is vital to getting them off drugs and to rehabilitating them.
Question
14, Mr. Speaker.
Mr. Speaker, juries are a vital part of our criminal justice system, and jury service is an important civic duty. And we want to do everything we can to help jurors and feel supported as they undertake this important role, and that's why the government has announced its intention to test counselling sessions for jurors who suffer mental and emotional strain following a trial. And that pilot will commence in 15 courts this summer.
Thank you, Mr. Speaker. Currently, jurors dealing with extremely violent crimes, witnessing ever increasingly sophisticated and graphic material, often feel like they don't have sufficient aftercare to deal with their experiences, are only advised to seek counselling with their GP or the Samaritans. So what discussions has the Minister had regarding increasing the amount of support for jurors post-trial when they have faced potentially traumatic levels of stress as a result of their experience?
I thank the Honourable Lady for her question, which is extremely relevant. And obviously, as you can imagine, there have been extensive discussions between the Department and the Judiciary about this, and the Senior Presiding Judge has approved the test sites for the pilot that I have just discussed. Support of the type that we are providing in this pilot has not been provided before, so the pilot itself is going to inform a very essential part of the judgment that we make as to whether and how we can carry on going forward.
Bomber.
15, please.
Access to legal aid matters, and we've taken action to broaden access in immigration and asylum cases by uplifting fees for work done under the IMA when it commences, providing up to £1.4 million this year for accreditation and re-accreditation of senior caseworkers conducting legal aid work. 3, allowing detained duty advice scheme providers to give guidance remotely where appropriate, and introducing payment for travel time between IRCs and DDAS surgeries.
Thank you very much, Mr. Speaker. The Bar Council of England and Wales has submitted their grave concerns to the MOJ's review of civil legal aid, citing it as not sustainable in its current form, significant concerns over the future of availability of counsel in immigration and asylum cases. The Bar Council also notes that in real terms, civil legal aid fees have now halved to what they were 28 years ago. So what are the next steps to ensure the future of legal aid in immigration cases, or is justice now for only the wealthy?
The Honourable Gentleman for raising that important question. So we are broadening access to legal aid. The means test review, when fully implemented, will put an additional £25 million into legal aid and bring an additional £2 million into the scope of legal aid. We're rolling out the Housing Loss Prevention Advice Service. That's another £10 million going in. There will be up to £141 million going into legal aid. And we're also rolling out the review of civil legal aid, which will be reporting later this year, and we will be issuing a green paper in July to look at what we need to do to have a sustainable, resilient and well-resourced system, because we want high-quality people, high-quality lawyers doing civil aid, legal aid. It's vital for the kind of country we want to be.
Number 18.
Number 18 is... That's me. Thank you, Mr. Speaker. Number 18. Number 18 is, we remain committed to reducing the outstanding caseloads across our courts in England and Wales. To enable the courts to get through more cases, we've extended the use of 20 Nightingale courtrooms this financial year. We've allocated £220 million for essential modernisation and repair work of our court buildings up to March next year, and we funded unlimited sitting days, including 107,700 days during the most recent financial year, the highest level since 2016.
Mr. Carmichael.
Anyone who has been the victim of crime, delays in getting cases into court adds massively to the stress and anxiety that they experience. So what would the Secretary of State say to any member of this House whose local magistrates' court had 1,954 criminal cases waiting to be heard at the end of December 2023. Would he say that a backlog of that scale was acceptable?
So he raises an important point about the Magistrates' Court. It's true to say that the caseloads in the Magistrates' Court, which of course deal with over 90% of crimes, that's common assault, criminal damage, non-residential burglary and so on, those caseloads are significantly lower than they were during the pandemic. The particular pressure is in the Crown Court. Now, we made a decision of principle during the white heat of COVID not to get rid of jury trials. Now, I know in Scotland the SNP government is a little ambivalent about jury trials. We think they're a very important part of the rights of freeborn Britons. We will hold fast to them, and we will put resources in more Nightingale courts, more judges, raising the retirement age, more legal aid. We will invest in the system, recover the system, whilst keeping fast to our principles.
Thank you, Mr. Speaker. When I was a Justice Minister, I introduced virtual hearings to make cases so that cases could proceed a lot more effectively. Would the Lord Chancellor kindly update the House on the progress of virtual hearings?
I'm delighted to hear from my honourable friend, who was such a distinguished minister in this department. And on the specific issue he raises, he introduced virtual hearings in our courts, and time has proved that he was absolutely prescient, because that was the right thing to do. Recently, I was glad to welcome the decision by the Judicial Office to make remote hearings the default position for bail applications, and more widely, my honourable friend for Warrington South's private members' bill is currently making its way through Parliament and will amend legislation so that magistrates and judges in the magistrates, county court and family courts will be able to hear those cases remotely in appropriate cases.
Number 19. Mr. Speaker.
Here we go. Number 19, Mr. Speaker. I'm my own time. I'm getting there. I'm just getting the right point. So, Mr. Speaker, the NAO report on management of legal aid was a valuable piece of work, and we're considering the conclusions carefully. The government hugely values the work of legal aid lawyers, which is why we commissioned the review of civil legal aid to identify options to deliver a more effective, efficient and sustainable system for legal aid providers. A green paper with policy options is planned for July this year.
Mr. Speaker, across Bedford Borough, there are no providers of housing legal aid. Living within 10 kilometres of provider of legal aid housing advice in England and Wales is down from 73% to 64% in the last decade. So does the Minister agree that whatever legal redress is remedied in the Renters Reform and Leaseholders Reform bills will be meaningless if there is no legal aid system to enforce those reforms?
Gentleman for his question. I hope he will welcome the £10 million that is going to the Housing Loss Prevention Advisory Service. This is an important and revolutionary step to ensure that those individuals who are at risk of eviction can access the legal aid they require to be able to make their case. We think this is extremely important, and I would respectfully invite him to come and speak to me, and I can discuss it more with him so that he can ensure he can be a voice to his constituents, signposting them to the support that is available. It's really important that they're aware of the support that the government is providing.
Question 20, Mr. Speaker.
Thank you, Mr. Speaker. The Government has taken significant steps to prevent domestic abusers from using the justice system to extend control over their victims, starting with Section 65 of the Domestic Abuse Act, which prevents them from cross-examining their victims and requires that special measures are available in court. We also amended Section 9114 prohibition orders, which can bar any individual from making a further application to court without permission, where abusive partners are judged to be bringing victims back to court without reasonable purpose.
Thank you, Mr. Speaker. My honourable friend takes domestic abuse very seriously, but will she know that perpetrators all too often seek to use the civil courts to perpetuate further abuse against their victims, often with legal aid, and using often experts with no qualifications or no relevant qualifications whatsoever to make accusations of child or parental alienation, child grooming, etc. Please can she reassure me that the government is taking this seriously to make sure that perpetrators don't continue to use our court system to re-traumatise their victims?
Well, I thank my honourable friend, the honourable lady, for her excellent question. Let me just remind her that this, in fact, is precisely the issue that Section 91 prohibition orders are directed at. And one of the changes that was made under the Domestic Abuse Act was to confer a power on the courts themselves to make these orders of their own volition rather than waiting for an application from the victim. The second part of her question was about legal aid, and I just wanted to say, to the extent we're making changes to legal aid, all of those are in favour of the victim. We're removing illiquid and contested assets from consideration of means. All protective orders can be obtained without any assessment of means, and we're undertaking a legal aid means test review to make the test much more generous to victims. The final point she asked about was about the so-called experts who give evidence on parental alienation. The government does not recognise the concept of parental alienation and does not believe it's a syndrome capable of diagnosis. We've responded to the Domestic Abuse Commissioner on this in writing.
We now come to topicals. Mr. Brenda Sharma.
Speaker, question number 1.
Since the last Justice Oral Parliamentary Questions, I met my G7 ministerial counterparts in Italy to discuss topics ranging from preventing illegal migration to tackling organised crime. We announced a new offence, which my G7 colleagues were very interested in, incidentally, to prohibit the creation of sexually explicit deepfakes. We announced measures to remove parental responsibility for those convicted of rape of a child. We progressed the litigation funding agreements bill through the House of Lords to support access to justice for those like the postmasters. We introduced an amendment to the Victims and Prisoners Bill to provide further protection for victims against unnecessary disclosure of counselling notes. And I attended the Unlocking Investment in Ukraine conference, which brought together Ukrainian lawyers and eminent British jurists. Can I say this, Mr. Speaker? We in this country understand the importance of a strong legal sector to secure Ukraine's future. Once it has won the war, the British people and this Parliament are determined that Ukraine should win the peace too.
Thank you. With more than 80,000 children caught up in private family law proceedings, what is the Minister doing to ensure the welfare of children is protected?
Can I thank the gentleman for raising private family law, because all too often people raise the issue of crime, but family matters too. I'm really delighted that we have managed to secure funding from the Treasury to roll out early legal advice in private family law that will sit alongside the Pathfinder pilot scheme that is designed to make the process of dealing with private family disputes more seamless, less painful, and ultimately ensures that children are put first.
Colburn.
Lincoln, Cheltenham and Wallington, particularly women being targeted for so-called crash for cash insurance scams. So could the honourable friend outline what support is available to victims of this sort of crime?
If someone is the victim of a crash for cash scam, they will be the victim, very likely, of an offence under the Fraud Act or indeed potentially under the Road Traffic Act. We have quadrupled funding for victims of crime. So that means that there are entitlements which exist under the Victims Code to be kept updated about the crime, to be notified about compensation, to be offered special measures if the case gets to court. We are determined whether you are a victim of crash for cash or the victim of theft or any crime, the state should be there to provide the support you need.
Secretary of State Shabana Mahmood.
Thank you, Mr. Speaker. This week, the Chief Inspector of Prisons found that at HMP Lewis, the government's early release scheme is undermining safety and risk management. In one case, a high-risk prisoner was released early despite being a risk to children, having a history of stalking, domestic abuse, and being subject to a restraining order. Is this the Secretary of State's idea of putting public safety first?
So I read that with care and will be looking very carefully at that specific case. I think it's important to read precisely what the Chief Inspector said. He said that that was an incident right at the beginning of the process, and he expected that things would bed down and things would moved on. The critical point is that under the government's scheme, if there is a concern about the individual who is proposed to be eligible for the scheme, the governor can impose that veto. It gets escalated to a panel for that to take place. That is an important safeguard, and it is one that was not present under the Labour scheme, as she well knows.
Mahmood.
Report after report, failure after failure. At Park Prison, 9 people have died in just 2 months. At Bedford, cells were flooded with raw sewage. And at Wandsworth, a suspected terrorist escaped last year. The prison still isn't secure, and the governor has resigned. She's taken responsibility. When will he?
So she's right that there are prisons where the standards are not where we want them to be. There are something like 120 prisons in the estate, and we are the party that created the urgent notification system so that these matters can be drawn to the attention of the government. But I would just make this point as well. There are prisons where they have failed in the past and we've turned them around. Take HMP Liverpool, which I went to, and in 2017, the honourable member who's the chair of the Justice Select Committee will remember there was a scathing report. It has been turned around. It is safe, decent, rehabilitative. Prisoners are doing excellent work. Take HMP Chelmsford, which had a UN and has been turned around. We take this incredibly seriously, but we are the party that is investing record amounts in our estate. And to the point about the Labour record in government, they boasted that they would bring on 3 Titan prisons. They brought on none.
Secretary of State, it's topicals. I've got to get your colleagues in, and I'm sure you won't want them to miss out. Let's start with Theresa Villiers.
Thank you, Mr. Speaker. A number of my constituents in Chipping Barnet tell me they continue to have problems with delays in getting court judgments implemented by bailiffs. So will the Secretary of State do everything he can to tackle delays in the courts and bailiff system, especially possession proceedings where there continue to be real problems causing delays and costs?
Thank the Right Honourable Lady for this important point. So fewer than 1% of tenancies required court action in 2019. However, for those difficult cases which do escalate to the courts, the government recognised the importance of making sure the process is smooth and efficient. Nearly 90% of county courts are currently listing possession hearings within 4 to 8 weeks after a claim is received. On bailiff recruitment issues, we are running recruitment campaigns and have reduced administrative burdens to free up resources for bailiffs to focus on enforcement activity.
Rachel Hopkins.
Thank you, Mr. Speaker. The government's latest panic measures to deal with the prison capacity crisis, expanding the early release scheme to 10 weeks, has simply fuelled the probation crisis instead, with staff warning that many of these releases are unsafe and result in recall in a matter of days. Can the Minister or the Secretary of State confirm what specific recent extra resources he's put into this struggling service so it can cope with the sharp rise in probation workloads?
Grateful to the Honourable Lady for her question. She's right to highlight the work of probation. I put on record, as I know my shadow would, and I know she would, our gratitude to all those who work in our probation service. In the long term, as she knows, since 2021, we've put an extra £155 million a year into the probation service, 4,000 more staff in training. But she will have also seen recently the announcement made by my right honourable friend, the Lord Chancellor, in respect of the probation reset to enable probation officers to focus their time on where it makes the greatest difference and has the greatest impact.
Are extremely full for the entirely understandable reasons the Lord Chancellor has set out, but that does mean that often they can't do the job of rehabilitation we would all like them to. So will he look again at the proposals I put forward with the Centre for Social Justice for a tough new sentence called the Intensive Control and Rehabilitation Order, served in the community but under very strict conditions, including GPS tags and compulsory courses to reduce the likelihood of reoffending?
I thank my honourable friend for his question, and I can confirm to him that officials have reviewed and considered the ICROs, which involve the use of electronic monitoring, curfew arrangements and rehabilitative requirements targeted towards offenders who would otherwise be in custody. And in June of last year, we began a pilot of a scheme that is very similar to the scheme that he proposes, which is intense supervision courts, which divert offenders with complex needs away from short custodial sentences and provide them with wraparound multi-agency support to target the root causes of their offending behaviour.
Cummins.
Thank you, Mr. Speaker. Today I am meeting at an event organised by my honourable friend from Bradford East with my constituents who were encouraged by solicitors firm SSB Law to pursue no-win, no-fee claims against effective cavity wall insulation providers. SSB Law subsequently went into administration, leaving my constituents with extortionate legal costs from defendant lawyers. What steps is the Minister taking to ensure that the Solicitors Regulation Authority has the necessary powers to provide my constituents with the protection, compensation and justice that they deserve?
Can I thank the Honourable Lady for raising that important point on behalf of her constituents? I'll write to her. Thank you.
James Gray.
Mr. Speaker, it's now 5 years since my constituent Ellie Gould was brutally murdered in her own home. Her assailant had been given a paltry 12.5-year sentence. Recently, a man who killed someone in the street, a stranger in the street, was given 25 years, but simultaneously on the same day, someone who cut his wife up into hundreds of pieces and disposed of the parts in a river was given a sentence starting at only 15 years. The Wade Review recognised there's a terrible disparity between domestic murders and non-domestic murders and called for that disparity to be corrected. Will the Secretary of State now tell us when he's going to reply to the Wade Review and I hope that he will take due account of it and will equal up these sentences so that people who are guilty of domestic murders pay the same penalty as those who kill someone in the street.
I thank my honourable friend for his question. In response to the Wade review, we've increased sentences by introducing statutory aggravating factors for murders that are preceded by controlling or coercive behaviour, that involve overkill or that are connected with the end of a relationship. And we have also consulted publicly on sentencing starting points for murders preceded by controlling or coercive behaviour and for murders committed with a knife or other weapon. And the Government is carefully considering these responses to the consultation and will publish its response in due course.
Mr. Speaker, the urgent notification issued last week to Wandsworth Prison raised the same issues found at HMP Bedford 6 months ago. Both revealed a horror show of violence and overcrowding in filthy environments with horrendous level of self-harm and drug misuse. The staff, they try their best but lack experience. So does the Minister accept that it's his government funding cuts and policy failures that have delivered a broken justice system that offers little hope, reforms for prisoners or protection for victims?
Mr. Speaker, no, I don't accept the premise of the honourable gentleman's question, which may not surprise him. But in respect of Bedford Prison, which he and I have spoken about, we continue to put the investment into both staff and the prison to make progress following that urgent notification.
Davis.
Thank you, Mr. Speaker. A constituent recently attended my surgery in Bishop Auckland to disclose her serious concerns about poor communications from both CAFCAS and the family court-appointed children's guardian in her case. This is an extremely distressing time for her and her family, so good communication is surely key. How can the Minister ensure that my constituents will receive the support and advice they need in a timely fashion?
Well, can I thank the honourable lady for being so assiduous in raising this important matter on behalf of her constituents. So we are investing heavily in the family system to deal with precisely these issues. If something has gone wrong in that specific case, perhaps you would be kind enough to come to me and we'll discuss it further.
Thank you, Mr. Speaker. There are presently 2,796 IPP prisoners languishing in our prisons, 705 of which are 10 years over their original tariff, and 112 of which had a tariff of less than 2 years and are now over-tariffed by 15 years or more. The MOJ's refreshed IPP action plan clearly isn't working. So what does the Secretary of State plan to do to fix this dire situation?
The total number of IPPs is slightly higher than that, but the really significant factor, if you look into the data, is that whereas there were something like 6,000 IPP prisoners in 2012, the number who are not being released is down to around 1,200 at the moment. And as I say, we have the action plan to try to address that. But the reforms that we're making are designed to ensure that when they are released, they are not faced with a licence period of 10 years, which can lead to them being recalled at any time. By reducing it to 3 years, that's a humane and sensible way to try to erase this stain on the conscience of our justice system.
So David Davis.
Yesterday, the New Yorker magazine published a 13,000-word inquiry into the Lucy Letby trial, which raised enormous concerns about both the logic and competence of the statistical evidence that was a central part of that trial. That article was blocked from publication on the UK internet, I understand, because of a court order. Now, I'm sure that court order was well intended, but it seems to me in defiance of open justice. Would the Lord Chancellor look into this matter and report back to the House?
Well, I'm grateful to him for raising it. Court orders must be obeyed, and court orders can be displaced by someone applying to the court for them to be removed. So that will need to take place in the normal course of events. But I would just simply make the point on the Lucy Letby case that juries' verdicts must be respected. If there are grounds for an appeal, that should take place in the normal way.
Speaker, Taunton Deane Magistrates Court had 1,027 outstanding criminal cases in the first quarter of 2023, and the Justice Secretary's own constituency, as of the end of December, had 1,954. These delays are really letting down victims, their families, witnesses and defendants, while undermining public confidence in the criminal justice system. So how does the Minister plan to tackle this backlog, and will he provide those working tirelessly in our courts courts with adequate support and resources to carry out their duties.
Increased capacity in the system. We have 20 Nightingale courts which are opened, which includes Cirencester Crown Court in my own county of Gloucestershire. We've increased the number of judges by 1,000. We've put up to £141 million into legal aid. We've raised the retirement age, and we're also ensuring that there is support for victims, including with ISVAs and IDVAs, and we've introduced a rape support helpline and so on. We are doing everything we can to support victims, increase capacity in the system, and heal the damage that was caused by COVID.
Committee, Sir Robert Neal.
The Lord Chancellor will know that there is particular concern at the growth of the remand population in our prisons, which causes great disruption. He will know also that senior presiding judges and others are taking innovative measures to list remand cases. But will he confirm, to support that there will be no financial cap going forward upon sitting days in the Crown Courts?
As always, the Honourable Gentleman gets right to the heart of the matter. So pre-pandemic, there were around 9,000 people in custody awaiting trial. Now the figure is closer to 16,000, and plainly that has an impact. And it's because we didn't get rid of jury trials, because that was the right thing to do. So I'm really grateful to the LCJ and the SPJ for considering remote hearings of bail applications to ensure that there are more lawyers able to do the cases. But having enough practitioners is critical, as well as sitting days. Both will be having my attention.
Thank you, Mr. Speaker. Last week's letter to the Justice Secretary from the Chief Inspector of Prisons highlighted again the dreadful conditions in Wandsworth Prison. Will the Secretary of State take urgent steps to end the overcrowding in Wandsworth Prison?
It was a hard-hitting, a searing report. I was interested to note that although there was the full complement of officers, it simply isn't delivering the regime that it should be. We absolutely accept that. Of course, high remand population is an issue in Wandsworth, but just look at Cardiff, look at Liverpool, where they have achieved really fantastic results. So it can be turned around. So we are responding rapidly. We've already invested heavily. £24 million has been spent, already deployed extra staff at all grades, and we will be providing support from a prison standards coaching team to offer face-to-face coaching for Band 3 officers, with further deployment shortly.
Thank you, Mr. Speaker. I appreciate that there's an inquiry being conducted regarding the Horizon scandal. However, what is the Justice Department doing to hold to account those lawyers who prosecuted some postmasters despite the evidence being to the contrary?
Anybody who appears in court, but particularly prosecutors, must be mindful of your solemn and sacred duty to disclose material to the defence which might reasonably be considered capable of undermining the case of the prosecution. That is literally the most important rule. If they failed in this case, then I would expect the appropriate authorities to take robust and prompt action.
Question, Imran Hussain.
Thank you. Since I last raised the question with ministers, it's now estimated that there are over 10,000 victims of the SSB law scandal. Like my honourable friend from Bradford South said, we're hosting an event later today to listen to those victims of the real impact on their lives. I extended an invitation to the Minister, and will he commit to my asks of real compensation and protection for the victims of what now is a national scandal?
Well, can I thank the honourable gentleman for that kind invitation, which I will consider, and I will respond to him in due course. Thank you.
That completes questions. I'll let the front benches clear.